People ask us if the property is in probate. In a court filing or the data you provide, you write the information about you also give us the information about the PR or the personal representative or the court appointee administrator of the state. But what about the properties in a living trust? What information do we have when a property is in a living trust? And when they ask us, it comes to us that they don't know the structure of the living trust. So maybe you already know it, but just bear with me. I'm going to walk you through steps of the living trust, and maybe in the process you also pick something that will benefit you. Imagine Thomas and Mary, they're 22 years old, in love with each other, they get married, they buy their first house, 1965. And the way they hold the title on a property was Thomas and Mary Johnson, husband and wife as joint tenants with right of survivorship. Now I put this thing here. In most states you don't see this text, but in some you will see it. And the purpose behind that is this, is that these individuals, by taking a property as a joint tenancy with a right of survivorship, they take advantage of a unique benefit of the vesting on title. What it means is that if at any time something happened to either one of them, Thomas or Mary, the other one automatically becomes the sole owner of the property by the virtue of recording a document, a recorded document saying, I, Mary, testify that Thomas Johnson, who bought the property or who signed on a deed with me in 1964, document number such and such in the state of California, county of San Bernardino, is the same person who passed away, and this, by the way, the subsequent document is his certificate of death. That's how it's done. So in other words, the chain of title is held perfect. Is held perfect. Now, here's what happened. In a process, let's say Thomas and Mary, now they are 65, 70 years old, and they decide to do estate planning. They see a couple of the relatives pass away, then the light goes on. Hey, you know what? We should really put the stuff in order because now we have 4 kids. And we want to make sure that there is no problem if something happened to us. So they talk to an attorney. They say, Mr. Attorney, at the time we got married, we didn't have anything. But now we have a network of about $2 million. We have this business, we have that. We want to do estate planning. And the attorney will says, okay, fine. What I suggest to you is this, is that we create a living trust and transfer your assets to the trust while you guys are around. Either one of you have the power to utilize and take full advantage of what you have or to liquidate any assets without any problem. But if anything happened to both of you, in that case, tell me who should be the one who has the power, like a sales manager, to be able to sell the properties and do what you want. So to do this, we're going to create a document which is called a trust or a land trust. Now, the trust is an amazing piece of document. And the original idea for the trust was, it came from British. In the old days, when there was all those kings, all that 15th century, the oldest son was the one who inherited everything, everything. Imagine you had one son and 6 daughters and 2 other sons, but the oldest one got everything. So the attorneys start thinking really hard. Well, wait a second, we can't go against the law of the land, but is there any way we can create a vehicle that will ensure the other kids will also benefit from the state versus the old son? So the smart attorneys came up with this idea. Let's create a document just like a corporation, and we call it trust. In that document, we put the oldest son's name as a trustee or a successor trustee, and then inside the document that is not recorded, we're going to list all the beneficiaries. So behind the scene, they're going to hold piece of the company or this is estate, but on the surface, nobody would even know about that. Okay, that's how the trust came to be. So in US, we use the trust. So let's go back to this example. Thomas and Mary talked to the attorney. The attorney created a living trust, and he said, guys, I want you to deed the property from your name, this vesting, to something else. So we're going to take this out, and they record the document. On the grant deed or quitclaim deed, they're going to say Thomas and Mary Johnson is a grantor, and the husband and wife as a joint tenancy hereby grants the property to Thomas and Mary Johnson, co-trustees of Johnson Family Trust, dated 12/8/2000. So this is now 30 years later. Okay, this is what public sees. A quitclaim deed recorded, Thomas and Mary Johnson, husband and wife, as a joint tenants, they did the property to themselves, but really they did it to the trust. So the question here is that if they did the property to the trust, who really owns the property? Do they still own it as individual, or the trust owns it? So let me tell you about the trust. Trust is a legal entity. In the eyes of the law, a trust or these individuals with a heartbeat is no difference. No difference. The law treats them the same. They have the power to sell, just like corporation, just like LLCs. However, there is no entity who can transfer the title without a person signing it. You follow me? Without a person signing, you'll never find that. So now the property is held in a living trust, and the attorney will say, okay, I'm going to put your name as a trustee of the trust, but in the event of your demise, give me a person or persons who are able to be acting as a successor trustee. And they say, well, you know what? We want to say first designate George Johnson, our oldest son, and just in the case he's not around, we want to nominate Edwin Johnson. He's our other son, and so that's where we are. And by the way, I would also put my brother, or she will say my sister, but those people are secondary or third or the fourth in line. They do this thing because just in the case they pass away and he passed away, now what? Okay, so the only thing he has to do to sell the property is to basically file one piece of document saying that affidavit of the death of the trustee. So now he becomes a successor trustee. That's the reason we call the site successors data. We're dealing with successors. Okay. Now inside the trust, we have the other kid's name and all of them. In fact, he himself is a successor trustee, but also a beneficiary. And all of them, then they can decide inside the trust, so he can get 1/4 and 1/4 and 1/4 and 1/4, and the total is 100% of the ownership. Now, you ask the question, if I know the property is in a trust, and you told me that this individual's passed away, who do I write the letter? Well, we don't know who is the successor trustee until that document is recorded. That happens usually at the sale. Most people do not go record the affidavit of death of a trustee right off the bat. They do it when they want to sell the property. So when you write the letter, guess who will get your letter? George will get it, or Edwin will get it. They'll be the one to call you and say, hey, you know what, I got your letter about that property, and the property is in a trust, and me and my brother are the trustees. We have full power to transfer property or sell the property. We have control over the bank account and all that. That's the reality, friend. So when a property is in a trust, your best bet is to write the letter to that property and ask and address your letter to dear property owner. So when we mail the letter, we send it to Thomas and Mary Johnson, trustees of the Johnson Family Trust, but on the salutation of the letter, we say, dear property owner, would you consider selling your property at this address? Please call me at this number.